Bismillah Rahman Rahim. Honorable former Chief Justice of Pakistan, Sir Hussain Jilani Sahab, Mr. Aqib Saeed Sahab, Chairman SECP, Honorable Judges of Lahore High Court, Sindh High Court, Balochistan and Islamabad High Court, respected members of the legal fraternity, distinguished guests, ladies and gentlemen, Assalamu alaikum. Before coming to Islamabad, I confirmed from the registrar, company judge at Peshawar, about the pendency of company cases before Peshawar High Court, Peshawar. I've been informed that there were only 35 cases pending and most of them belongs to liquidation. And only there is one case pending in evidence. And probably that was the reason that I have been assigned the topic of cross-examination. Moving towards the topic, assigned topic, ladies and gentlemen, so far as cross-examination is concerned, as we all know, is a vital component in the testimony of a witness, which plays an important role in the decision of a case. The purpose of cross-examination is to help to reveal the truth of the matter pending before it. Decisions of the cases depends upon the quality of the evidence produced by the contesting parties. Certainly, testimony of a witness starts from his examination in chief and closes on cross-examination, and indeed it is the cross-examination which determines the standard of the evidence led by a party. This is a skill which comes through regular, constant, practical practice, as there are no shortcuts to become master in cross-examination. One of the golden principles of the cross-examination is that never ask a question which answer is not known to you. As cases make and break through cross-examination. And certainly one loose question destroys entire evidence of cross-examination, like unwise move at chessboard ruins the entire game plan. It requires the preparation and alertness of mind. Though in the cross-examination, the witness is in the hands of the opposite counsel, however, law has imposed certain restrictions and limitations which are to be respected at the time of conducting cross-examination on a witness. Indeed, the appreciation of evidence in cases is quite different from each other. As in criminal case, standard of proof is based upon the principle of proving a case beyond a reasonable doubt, while civil cases decide on the principle of preponderance of evidence. Therefore, great attention is placed on the personal appearance of witnesses in the criminal cases in order to see the demeanor of a witness during the testimony which is relevant in its decision. It is settled that cross-examination must be precise and to the point. In our part of the region, there is tendency of lengthy cross-examination, which practice has always been deprecated by the superior courts. Such practice is unrestricted cross-examination was seriously condemned for the first time in Muhammad Shafi's case, reported in PLD 1976, Supreme Court 167 by His Lordship. Nonetheless, Justice A.R. Cornelius, in the terms, I quote, "It is improper to cross-examine a witness for an extended period of time in an attempt to cause him to make a mistake after his alertness has been compromised by exhaustion and his ability to resist suggestion offered in the form of leading question has been diminished." And till date, this view is followed rigorously by the courts, by superior courts of the country. I would share by experience regarding the semi-adjournments of criminal trials due to want of appearance of the prosecution witnesses before the courts. Due to certain reasons, the prosecution witnesses avoid to appear before the courts, and the benefit always in those cases used to go to the accused who, while applying for their bails, used to be released on bail applications by entertained by the courts under statutory grounds. Now the introduction of the information technology and adaptation throughout the country, at least that one hindrance has been removed, as the courts throughout the country has recording examination of the witnesses in criminal cases through video link. Most recently, in the year 2020, Lahore High Court allowed the examination of a witness through video link in a compromise matter which was settled between the parties. Likewise, Peshawar High Court allowed the examination of prosecution witnesses through video link from Saudi Arabia, and thereafter a long line has been followed by the courts throughout the KP by recording the testimony of the prosecution witnesses from throughout the world, including Europe, Middle East and America. Now the witnesses need not to approach the courts for recording their cross-examination, for recording their testimonies in cases, whether these are civil or criminal or other related matters. Rather, we at the KP has provided one window operation. It depends upon the parties. If they apply for recording of the their witnesses, they can simply move an application to the concerned court, which is decided within 72 hours with one window operation, and arrangements are made for recording such examination through foreign office. And they are allowed, then understanding the facility inside the Pakistani missions. The witness appears from there, cross-examined from there through video links. So it is a huge milestone in the history of judicial history of the country, particularly in our region. Peshawar High Court Peshawar has extended the facility of these information technologies to all 35 districts. The population of the Khyber Pakhtunkhwa is now round about 39.69 million, which is round about 4 crore. And we have facilitated every single individual whose case is pending in any court, right from the court of magistrate till the court of high court, we have provided such opportunity. And indeed, a remarkable achievement, a remarkable progress has been achieved by the High Court Peshawar. In the last year, we have concluded more than 16,000 cases via the video link, through video link. Started from district Chhatral to DI Khan, from south to north and from east to west. We have provided that opportunity to the litigants. Again, in criminal cases, in all the major divisions of the country, of the Khyber Pakhtunkhwa, the under trial prisoners are appearing before the courts through video links. No, there is no need for their production before the criminal courts, before the trial courts for recording, for facing their criminal trials. Rather, they are participating from the jail premises wherein sufficient facilities are provided. And constantly the same are being looked after and managed by the High Court itself by constitution, a separate unit for it. These were the experiences of the Peshawar High Court to share with the support of the SECP, as they have provided us to share our experiences in the matter of the recording of evidence in the cases through IT as well as otherwise. It is very interesting to note that the prolonged untidy cross-examination has also been deprecated by the August Apex Court in the recent case decided in the year 2022 in Mesha Shafi's case, in which the court has observed that 24 pages cross-examination has been conducted on the plaintiff, on the respondent, on the defendant, which has been deprecated by placing reliance in the case of Muhammad Shafi as reported in the year 1967. So, this very objective of the cross-examination, the very purpose and objective can not be achieved through lengthy and untiring cross-examination, rather the same can be achieved through short, precise and relevant cross-examination. Thank you very much, SECP, for providing an opportunity to share our experiences with the honorable members of the superior judiciary as well as members of the legal fraternity and distinguished guests. Thank you.